Well, the Texas Family Code and Constitution defines marriage as the union of one man and one woman. However, earlier this month, the state courts granted a divorce between two women. It begs the question as to whether same-sex couples should be allowed to divorce in Texas. Sonia Kaufman joins us now with more and answers to your questions regarding family law. And this is very interesting for the state of Texas to even grant a divorce between two women.
It is. Greg Abbott, the Attorney General, appealed the court in Austin granting the divorce to two women, and the Court of Appeals in Austin said that the divorce stands. So the question's not over because there's also an appeal from a Dallas divorce before the Court of Appeals, but it's a very fluid area in the law right now.
And we've got lots of questions, so we'll get to those from our viewers. This one says, my ex-wife says she claims our daughter as a dependent when filing for taxes. There are a large number of children in the household and only 3 can be claimed as dependents. I'm curious, can I take my daughter or take my ex-wife back to court and have the judge allow me to claim my daughter every other year? I think it would only be fair.
That is an interesting question, but it's not really a legal question. It's a question for the IRS because there is a specific publication that's available online. I think the number may be publication 501, but double check the number. But it deals specifically with which parent gets to claim the exemption in the event of a divorce. And
is that not typically in the divorce decree?
Sometimes the parties will agree to alternate years, and it's part of the overall bargaining, but the courts generally say that the parties follow the Internal Revenue Code in making that decision.
Ooh, so 501 you think
I think it's 501, yes. It's specific examples of divorced families and children, and the general rule is the parent that has the child more than 50% of the time
they get to claim
would get to claim them. Yes.
Okay, on to our KFDM News Facebook page. A question. I would like the father of my sons to sign over his rights and drop the child support he owes. Is this something I have to take to court?
Yes, you would. And judges are very skeptical of parents who want to relinquish their rights for the purpose of avoiding child support. So I think that's a very iffy proposition of whether the court would approve that. If there's a step parent ready to step in and take over the child support obligations, then or the support obligations, I should say, then the courts would be more inclined to grant that. But just to avoid child support is probably not a good idea.
Okay, another question. I would like to know if someone owns property before they're married and then they die, does the property go to the surviving spouse or the child of the deceased?
Under the laws of intestacy, it would be divided between the spouse and the child. And the best thing would be to consult a probate attorney for the specifics on that.
All right, and we've got lots of other questions, and we'll have to get to those next month. I'm sorry. Thank you so much for joining us. We appreciate it. Well, and if you have a question about family law, let attorney Sonia Kaufman answer your questions. You can always fax those questions, 892-7305, email us at laf@kfdm.com, or just post your question on our KFDM News on Facebook.